Please be seated. We'll hear argument in 21-10-14, Skeels versus Suder.
An argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. I'll begin this morning by quoting from my friends at the respondents' table. Quote, Section 303.004 is the controlling statute, and it's really very simple. Close quote. That statement was true when council made it in September of 2017, and it is equally true today. So with that statement as our poll star, I want to focus on 3 points this morning. First, Texas Business Organizations Code Section 303.004 is, in fact, the controlling statute here, and it is the only issue that this court needs to address because the 2014 resolution, however it may be characterized, does not comply with Section 303.004. Second, if the court prefers to address additional errors made by the lower courts, then it should take the opportunity to clarify that BOC Section 21.101 does not authorize share redemption, and even if it did, this nondescript resolution does not qualify as a shareholder agreement under 21.101 and does not include the requisite specifics to authorize share redemption or cancellation. And third, this court should take the opportunity to clarify the legal duties owed by the corporation and the remedies available to shareholders when a corporation impairs a shareholder's property rights, particularly in the context of share redemption and the improper withholding of dividends. To my first point, this court can resolve this dispute by simply clarifying that Section 303.004 of the BOC governs the manner in which a professional corporation may redeem shares. This court could adopt the original unanimous opinion from the Second Court of Appeals, authored by Justice Birdwell, a very thorough, well-reasoned, 37-page opinion, and be done with it. As Justice Birdwell explained, regardless of whether the resolution is or is not a governing document or a shareholder agreement, regardless of how it's characterized, it does not comply with 303.004 and therefore does not authorize the redemption or cancellation of shares. And in that vein, the last thing I'll say on this first point is this court has an opportunity to endorse a statement that has been made by the Second Court of Appeals in the Cotton versus Weatherford Bank Shares case, Fort Worth 2006, and the Herring Bank Corp case out of Amarillo in 2017 to the effect that the courts and the common law should require strict compliance with redemption-related statutes. To my second point, if the court does address the Chapter 21 issues, then it should clarify that Chapter 21 does not authorize a shareholder agreement that purports to establish the terms of redemption. And even if it did, the resolution in this case did not satisfy the strict requirements of Section 21.101A12.
It would seem that the resolution could confer on the managing partner the power to negotiate and offer terms. But your argument is that it doesn't confer the power to compel acceptance by a partner or shareholder, in this case, acting in his or her individual capacity in a transaction where the two are adverse to each other.
I think that's right, and I think Professor Miller in her amicus brief made that very point. She doesn't concede, I don't concede that it's a valid shareholder agreement. I'll come back to that in a moment. But even if it was characterized as a shareholder agreement, arguably it puts these gentlemen in a position as governing persons to speak on behalf of the corporation to negotiate with me. as to what the terms of some sort of redemption might be. That's, I think, what Professor Miller said. But they didn't do that. They didn't come to me and say, hey, let's talk about the terms of a redemption agreement. Let's try to lay those out in some sort of written document. That never happened. But before we get to, conceding that it is any sort of shareholder agreement, there's at least 3 reasons why it's not a shareholder agreement. Before we even get into any statutory construction issues, we can deal with the basics of contract law, which is that it's not an enforceable agreement because it doesn't recite any consideration. There are no obligations put upon either party in this resolution. There's certainly not mutuality of obligation, which is what the case law says is required to have a contract. So the respondents seem to be saying simply because the parties maybe agree on something makes it a binding enforceable contract. It would be like, Professor Blaine, if you handed me a note that said, it's a beautiful day outside, don't you think? And I wrote back and said, yes, it's a beautiful day, I agree, signed David Skeels. We've agreed on it.
Doesn't your construction, though, really undo the validity of unanimous written consents, which are used all the time to conduct, to authorize someone to conduct business on behalf of a corporation or a partnership?
I would say...
You're saying they're just all these unanimous written consents are invalid, and that doesn't seem to work.
No, I don't...
in the way that I think people ordinarily expect them to work.
No, again, I think that's exactly what the point that Professor Miller made in her amicus letter is that we can't give this the force and effect of a shareholder agreement authorizing redemption because there are tens of thousands of these types of resolutions floating out there. I'm not saying they're not operable as a governing document. I'm not saying it's not operable as a shareholder resolution.
I thought you just said that they lack mutuality and are unenforceable.
As a shareholder agreement. I mean, that's why the code distinguishes between governing, what are the words? A governing document or a shareholder agreement. And the governing document is an umbrella term that includes various types of agreements, resolutions, and shareholder agreements. But the code speaks in terms of a shareholder agreement to suggest it must be a binding enforceable contract. And a binding enforceable contract in this context means a shareholder agreement that reflects mutuality of obligation. And we don't have that here. But again, even if it is a shareholder agreement, I would just say it's not a binding enforceable shareholder agreement because it lacks consideration, and of course that agreement.
So if I signed a unanimous written consent and said, I give you, my shareholder, my partner, authority to negotiate on the partnership's behalf to acquire some land, and then later I really disagree with how that's handled, would you say that my consent to that authority is not valid? Because it wasn't a shareholder agreement?
Well, again, if you're trying to fall within one of these statutory provisions, 21.101 or 21.714, which I hope to discuss at some point, I would say that does not qualify as a shareholder agreement. If it lacks consideration, if it lacks mutuality of obligation, and those issues are properly preserved, which they were here, then it's not a binding shareholder agreement. But in any event, this document, however you characterize it, doesn't address redemption, doesn't set out the specifics that are required by 303.004. I mentioned a moment ago 21.714. That's in tab 14 of the notebook that I provided this morning. And the Court of Appeals, the Second Court of Appeals, repeatedly refused to address this provision because I don't think it knew what to do with it. This provision in 21.714 makes it clear, well, the code makes it clear that corporations have the latitude to operate with a fair amount of flexibility. The closed corporation statutes, subchapter H, give even greater flexibility and specify certain things that can be done by way of shareholder agreement. I actually shepherdized this statute, Justice Boyd, and I was surprised that Ritchie case didn't come up, but I looked a little bit more closer, and on page 871, you actually quoted and paraphrased this statute without actually citing the statute, making it clear that closed corporations have even greater flexibility to do certain things, including by way of shareholder agreement. What's noticeable is that this language in 21.714B3 is not found anywhere in 21.101. It's not in A12, it's not in A7, it's not anywhere else in the statute. And then, of course, we reach the point that 21.101A12 has additional requirements. It's a stricter subsection that says it has to comply with public policy. This court has accurately stated multiple times, including in the Ritchie decision, that the state's public policy is reflected in the statutes that it creates. So one of the reasons I provided this entire notebook is because it's sort of a pared down version of the BOC with all the provisions that I think are relevant here. And if you look at 21.303 through 306, it makes it clear that this legislature has found it appropriate to make sure that when you are dealing with redemption, that you get very specific. You specify the terms of the redemption. In fact, one of the best indications that this is not a shareholder agreement is because the respondents never believed that it was a shareholder agreement. If you look at tab 3 of the notebook, we have there section 21.103. Now, of course, even if you don't comply with this, there's some language that says that doesn't necessarily render it unenforceable, but it's a good indication that when the share certificates were issued and this resolution was drafted, that happened at the exact same time in February of 2014. If the respondents thought this was a shareholder agreement, which they didn't, they should have noted it on the certificate. That's what 21.103 sub B specifies. And then, of course, there's constitutional considerations. The majority opinion from the Second Court of Appeals is inconsistent with the Texas Constitution, which requires laws that provide fully for the adequate protection of the individual stockholders. I've included that constitutional provision at tab 1 of this notebook. And unless this court overturns and reverses what happened at the Second Court of Appeals, we're going to be left in this state with an interpretation of a statute that does not provide for adequate protection of the state's stockholders. And to my third point, this court can and should take the opportunity to emphasize that shares are property and that corporations owe a duty not to impair the property rights of individual shareholders. As Professor Snyder and Mr. Fryer said in their amicus brief at page 39, quote, "A corporation breaches those duties if it cancels a shareholder's stock, denies that the shareholder is an owner, withholds the shareholder's dividends, or otherwise acts to impair the shareholder's fundamental property rights." And I think the easiest way for this court to further emphasize that minority shareholders do in fact have remedies available to them is to take a look at the Ritchie opinion at footnotes 53 and 56, and there's a lot of material there to further expand upon the causes of action that are in fact available to minority shareholders. There are statutory provisions in 11.404, which the Ritchie opinion addresses in some detail. There's conversion, breach of fiduciary duty, potentially breach of contract, unjust enrichment, and so forth. And so finally.
Could I take you back to the point about consideration and mutuality? I'm just wondering what that would look like. If everybody agrees they want to give somebody the power to do something on behalf of the organization, how do we know whether there's adequate consideration for that if there is such a requirement? Well,
I think the City of the Colony case that we cited talks about mutuality of obligation and what that looks like. You know, it's a bargain for exchange. Again, I'm not suggesting that resolutions can't be used or shouldn't be used. I'm saying that the bigger problem is turning what was otherwise intended as a unanimous resolution. I mean, under this Second Court of Appeals interpretation, you take every resolution, unanimous resolution in lieu of a meeting, and it says that so-and-so is a governing person and they have the right to act on behalf of the corporation. Under the respondent's interpretation and the Second Court of Appeals interpretation, they all of a sudden have the authority to do any sort of act, including redeeming a shareholder's shares for $0. That
I
just,
guess the difficulty is figuring out what the limit of the authority is, right? So you said yourself, you don't contend that a resolution is meaningless or unenforceable in its entirety. Would you agree that you gave them authority to sort of pick out the drapes and pick pencils? And so where do we draw the line between, that on the one hand and redemption?
yeah, I was thinking more along the lines of authorizing them to, call the copy repair service. That's one of the examples that came up in the lower court. But to your point, I think if you're going to do something and claim the authority of 21.101 because you're claiming it's a shareholder agreement, or you're claiming the authority to do something under 21.714 and you're claiming you have the right to do that because it's a shareholder agreement, then I think you have to meet that higher standard. So I think the answer to your question, Justice Huddle, is look at the things that are listed in 21.101, A1 through 12, or in 21.714, however many subparts are there, about 15. And if you're claiming to do one of those things claiming to have the authority to do one of those things listed in those 15 subsections, then you ought to have to meet a higher standard and show that it is a shareholder agreement that is a binding, enforceable contract.
Does the resolution meet that standard by permitting the founding shareholders to take action by or on behalf of the partnership and or by any other shareholder, whether individually or collectively?
No, I would say it does not.
Okay.
And in fact, we brought it up repeatedly. Please point us, the respondents or Second Court of Appeals, please point me to somewhere in this document that you claim recites some sort of consideration. They didn't even attempt to do that. They just relied on a waiver argument. And the Second Court of Appeals similarly...
Does consideration have to be recited for it to be valid, or is that something that will be presumed absent a showing that there was none?
Well, you can have a presumption of consideration in a written contract. I think the respondents briefed that, and we addressed it in our reply brief, but it's a rebuttable presumption, and we provided some case law in the reply brief making it clear that that presumption in this case has been rebutted. And again...
What's the evidence in the record that there is no consideration?
The resolution itself. It's 2 or 3 paragraphs, and there is no mutuality of obligation recited in the resolution.
Why isn't the consideration that you don't have to worry about the copier? I mean, they're doing things on your behalf, on behalf of the firm that now you don't have to think about, and so that's good for you until you don't like the things they do, which is, raises other issues, but just in terms of consideration, why wouldn't we look at that?
I'm not sure I follow. So I'm agreeing that
there's a benefit to you from not having to concern yourself with the management of the firm until you don't like the decisions. But it's not that this is entirely unilateral without any reciprocal benefit to the other shareholders.
Well, I mean, it's an interesting thought. They haven't raised it. The Second Court of Appeals didn't raise it. I suppose the answer is, again, if you claim to do something under 21.101 or 21.714, you have to be able to meet the burden to show that it's a binding enforceable contract. And again, that would require some sort of recital and evidence of consideration. I think you're filling in the gaps as to what might be perceived as consideration here in this resolution, but again, it's not recited. They could have made that argument, and they didn't.
Any other questions? Thank you, Mr. Skeels. We'll hear from the respondents.
May it please the court, Mr. Cook and Mr. Myers will present argument for the respondents. Mr. Cook will open with the first 15 minutes.
Mr. Chief Justice, may it please the court. I'll pick up just where we finished off if it's convenient. In addition to the points justices made about consideration, we'd also need to point out waiver very briefly, and that is to say that it was never rebutted. There's law that says that when there's a written agreement, consideration is presumed. That was never pleaded. Also, even after the judgment was entered, we had a 4-month period where there were motions for new trial, several motions for new trial, judgments, amended judgments, and counsel never raised the issue of consideration. The whole point is to give the court a chance to correct it, but he never did. So that issue's long gone.
But even if there's consideration, 303.004 gives you 2 options for how you can agree to the price and terms of a redemption. And I think everybody agrees there was no agreement here on the price and terms. So all we're left with is B2, is whether the price and terms are specified in the governing documents or an applicable agreement. And there doesn't seem to be anything in the document that you're relying on that specifies the price and other terms.
So let me address that this way, Your Honor. I'm glad you raised that, because I think it's important. Exhibit 5, oral argument Exhibit 5, is the shareholder agreement in this case, the resolution. So the very first paragraph talks about a policy and practice of the firm and a right possessed by the founding shareholders. And then it goes on and it says that that right existed before any other shareholder other than the founding shareholders joined the firm. That was in place. Now, Mr. Skeels and other junior shareholders became a shareholder with that in place, okay? And so those rights and privileges in the record, so there's no doubt, there's no challenge that that policy and practice is in place.
But where does it specify the price and other terms of a redemption?
Well, it doesn't have to, Your Honor. Let me say it this way. Because the policy and practice included matters, we'll talk about the breadth of the agreement in just a matter, but it included matters involving departing shareholders and therefore redemption or reacquisition of shares, all right? And so that's record evidence that I can cite to you specific pin sites if necessary in the record. So what we're saying then is that that informs the meaning of what affirmative action is, those departing shareholder type things. Affirmative action is what we are entitled to take at that point. All you need to do now is look at Section 303.004, the statute you're referring to, and if you look at B, it says that there would be an agreement that's the price and other terms of redemption of shares may be, look at subpoint 1, agreed to between the board of directors and the professional corporation. That is this. The breadth of this agreement encompasses that. If you notice, the part he highlighted is the second part. It's point 2. And point 2 is the part that says the agreement must be specified, the price and terms must be specified in the governing document. So that's what he's focusing on. He's trying to take that and tie that around our necks, but we don't need to look at that because we had this agreement in place with these rights, privileges, and practices before he ever joined the firm, and also when he signed this resolution. So that satisfies, before we even get into what I'll talk about in a minute, the reconciliation of Chapter 21 and 303, we meet this chapter right here under B1 because we have an agreement, and that does not require a specification of price or terms.
Well, it does. Under B, it says the price and terms may be agreed to.
That's right, but you have to read that in context of B2. B2 is the one that says if specified. So what they're trying to do is so let me say it this way. It's our position that we meet B1 because you don't have, the question is, do we have an agreement on price and terms, an agreement between the board of directors and the corporation? Our position is that's there. If you try to say that there has to be a specification specific on price in the agreement, then you're jumping to B2, which is disjunctive. We're not required to do that.
Okay, I understand it doesn't say specified, but what was the content of the agreement on price and other terms under your theory under B1?
Let's go to the resolution itself. The resolution is that we have the right, power, and privilege to take certain actions. That included a broad swath of things. So if we want to look at the objective meaning of the word, okay? The objective meaning of the word is we're entitled to, quote, take quote, affirmative action, close quote. On its face, that includes redemption or reacquisition matters. And one of the best evidence is look at this same page, Your Honor, at the
If
very
it
bottom. We
says
cite
that
his
action-
statement where he agrees with us.
If it says that that action is taken on behalf of the firm,
Right.
could it just as easily, could the resolution just as easily be read to be an agreement that the founding shareholders take action, can take action on behalf of the firm? But that doesn't necessarily convey that they can also take action on behalf of a shareholder acting in his or her individual capacity.
Well, I guess I disagree.
That's what I'm trying to figure out.
Yes, I disagree with the way you're characterizing that. Because if it's the firm that's taking the action to reacquire the shares of someone else, that's action, the firm's doing that. Those shares then become effectively canceled. You can call them treasury stock, you can call what they are, but the firm is actually reacquiring those. So it
Yes.
does have the scope to do that, the power to do that.
So you could authorize the redemption on behalf of the firm, but how does this agreement authorize the redemption on behalf of the individual shareholder who's on the other side of that transaction?
Well, I guess I don't understand conceptually, Your Honor,
Okay.
because if we can acquire the shares, we're taking if the corporation's acquiring the shares, it's taking the action to obtain those.
But the statute requires something beyond that, beyond the authority. It requires agreement on the price.
Well,
And I understand what you're saying. Your resolution gave the firm authority to act, but what 303-004 requires is that the agreement be between the board and the shareholder. So what can you point to show that the shareholder agreed to the price?
well, the argument, Your Honor, is that, well, two things. Number one, what's in the scope of, quote, affirmative action, but also if you look to Chapter 21, 101 and 104, those are statutes that grant the power to have a broad agreement. The catch-all provision would permit this, and then it permits shareholders to agree have agreements even if inconsistent with this, with the code. These provisions fall within the code. So if you look at our exhibit, I guess it's 2, you'll see 21-104. In other words, this is where you're putting the sanctity of contracts, the ability for parties to reach agreements, even if inconsistent with, and that's our second argument, which I think is even the better argument, is that we can have agreements that are inconsistent with that. So what they're trying to do is say, well, we're going to try to import or impute these requirements in 30304 into Chapter 21. But that's not proper. As this court has said many times, you don't do that. You don't rewrite the statute. That is Exhibit 4. That's effectively what he's trying to do if you look at that. We've redlined and shown he's trying to say, well, you could have a shareholder agreement, but if it comes to redemption, you got to specifically say that. Chapter 21 doesn't say that. It just says you contract inconsistently. And our agreement does that.
The shareholders signed the 2014 resolution, presumably in anticipation of the IRS audit, to kind of get everything in order. Am I right about that?
That was part of the circumstances. That's correct.
And so does that mean that had they not signed this resolution, there would not have been any kind of corporate governance document that identified who could manage and make decisions for the corporation?
There were, I would say this, the practices of the firm had been that the 3 founding shareholders had done that sort of thing. Just as the practice of the firm had been that the 3 founding shareholders financed the firm.
But it wasn't documented, and that was part of the reason why this was signed, was to make sure that was clearly documented.
That the swath of power that the founding shareholders was, yes, that it was documented to that extent. That's right.
In the absence of that, had there been proper documentation that had a majority rules kind of approach, shareholder vote, in the absence of some either past practice or specific written resolution like this that said the 3 founding shareholders get to govern, presumably the normal circumstance would be the shareholders vote to make these major decisions on behalf of the corporation.
That's not the way it worked, Your Honor. Everyone knew that the founding shareholders made all decisions of that nature. We may have votes, but we decided all issues. And if you think about it, it makes sense. Because
Okay, but what I'm getting at is, let's assume that there was never a need for the 2014 resolution, because from the time in what he started in '07 and the firm was 1992 or something, I don't remember, but let's assume from the very beginning there had been more than adequate documentation that says we're incorporating as a firm, here are the 3 founding shareholders, no matter how many shareholders are ever elected in the future, these 3 make all decisions for the firm, right? Assume that had been from the beginning. Your position would be that document back in 1992 would have the same effect as this resolution, that it would have given them the power to redeem the shares for 0, no matter whatever, unless some opposite agreement was made in the future.
that is correct.
So basically what you're saying is that any formation or governing document that identifies who gets to make, what's the right word, decisions that govern the exercise of corporate powers, any document that identifies that on behalf of a corporation authorizes whoever that is that gets to govern the exercise of corporate powers, authorizes them to redeem shares for 0.
That's correct.
Okay. Regardless of Chapter 21.
Well, Chapter 21 permits that. I mean, we can do it regardless of Chapter 21, but Chapter 21 provides further support for that. This resolution was a memorialization of what you've described in practice. It just came about in writing in 2014.
What I'm getting at is this case is a little unique because you've got the operation of the corporation for a number of years without clear written designation of who makes decisions, and then you end up in 2014 with that document. But the gist of your argument is not dependent on that. The gist of your argument is whoever gets to make decisions for the corporation can always, by virtue of that power, has the power to forfeit a shareholder's shares for 0.
Yes, and it's specifically important here because he agrees with this. If you look
Well,
at
all he agrees with there is that the 3 get to make the decision.
No, that's Your Honor. Look at his deposition testimony. If you look at affirmative action, which is the language in the resolution, he says redeeming shares would be a type of action that could be considered affirmative action. That's the language in the agreement that grants us the power. And that's important because it's not just it's not just an admission by a party opponent for evidence purposes. That's a judicial admission. It's in a judicial proceeding. It's an under oath in a deposition. It's clear and unequivocal, and it's against his interest.
But it doesn't admit...
clear and unequivocal? I suppose redeeming shares.
Your Honor, I mean, we're specifically talking about I mean, he doesn't say no way. It doesn't. Can't do it. He says yeah. And that's in a sequence of a number of other questions where he's asked, yeah, that's included. That's included. That's absolutely clear and unequivocal in these circumstances.
What does it mean to redeem? Do the shares need to be tendered or offered for redemption? Or are you saying that corporations just can unilaterally decide to redeem?
Well, we followed the statute, Your Honor. So in other words, when we could not, it looked like we were going to have a difference of opinions on how to work things out, Mr. Myers, our counsel, looked at the statute and said, okay, if we're going to work this out, here's the section where we say, here's where we're going to give you notice of the redemption. Here's the date in which it should be done. Here's the price, 0. If it doesn't happen, we would consider your shares redeemed. We're following the procedure. That's what happened. He didn't come with his share. We didn't provide him any money for it, but that's practically the effect of what happened.
You know what I'm kind of getting at is, would your position be the same if the 2014 resolution had never occurred? If that had not happened,
yes.
And he had been hired in '07, and then in whatever year he was terminated, 15 or whatever year it was, 17, your position would be, even without that 2014 resolution, the long-standing practice of the firm had given these three shareholders the right to do exactly what they did here.
Yes.
So you don't really need the 2014 resolution for your position here.
Well, it's helpful, Your Honor, because if you look at Chapter 21.101B1, it talks about you need to comply with the statute. For example, have it in writing, have the shareholders sign it, be made known. Certainly, he knew. But now we've touched all those touchstones in 21.101, and so now it makes it clear that we have this, even though it's inconsistent with what he says we should have done. That the agreement controls. And I think this is really important that you're pointing this out, Your Honor, because what he's asking you to do, he's asking courts to intrude into the private affairs. It's been a long policy of this court that people make deals, they're free to make deals, and you stick with those deals. We don't want courts unnecessarily interfering when they have an agreement on this subject matter. And that will be violated, what's happened here. And it's, again, I call it especially inappropriate because he agreed with us. And that's also, I would say, why there's a discussion about public policy. Oh my goodness, this garden variety resolution may be used in other situations. That won't happen. Every case is going to be judged on its own facts.
Your position is that you satisfy 303.004B, but your position also is you don't have to satisfy it because of 21.104?
That's correct.
And is that the only reading that we can give of 21.104? Is it not possible also to say that the agreement is effective even if the terms are inconsistent with the code, in that we're not going to destroy the entire agreement? The agreement still is effective, but it doesn't necessarily mean that you can simply violate any specific provision of the code, does it?
I'm sorry, could you restate that? I'm not sure I followed.
Well, I can imagine an argument that an agreement that has some terms that are inconsistent with this code, someone might come upon later and say the whole agreement is invalid, ineffective. That would be very disruptive to a business organization.
Yes.
But it does not necessarily follow that because the agreement is still effective, despite having some terms that are inconsistent with the code, that any agreement can simply ignore every provision of the code, and those inconsistent provisions must invariably be enforced by the court no matter what public policy says, no matter what specific provisions of the business organizations code says, et cetera.
Well, if I understand your question, there are limits on what the agreement could come to. So, for example, you just mentioned one that's expressly mentioned in the statute. If the agreement was against public policy, well, we couldn't do that. Let's say, for example,
that's part of the code, and what you're saying 21.104 means is that you don't have to follow the code, which includes the requirement that it be consistent with public policy. So I'm not sure how far this argument goes.
Well, I think the way I would say that is that, let me pull out 21.104 to make sure I'm tracking with you exactly.
Tab 2 of your book.
Thank you. So a shareholder agreement that complies with this subchapter is effective. Now, what that's referring to is 21.101B, which says here's what you have to do. It has to be in writing, has to be made known to all the partners, and the shareholders, and it has to be signed by all the shareholders. So in that sense, there we have complied with this subchapter. That's the first sentence in 21.104. And then it says that if you do that, then the agreement's effective even if the terms of the agreement, right? That was sort of the procedural niceties. Even if the terms of the agreements are consistent with this code. And code includes, it's little c, that includes the entire code. 303, 21, all provisions of it.
If we conclude that 303.004 is in fact required, despite this language that you're making, and if we don't think that you've satisfied A, B1, or B2, are you left with the argument you made to Justice Boyd that you wouldn't even need this, that somehow you could redeem these shares despite not having these specific agreements, or would that also fall because your prior practice also would not satisfy B1 or B2 regardless of whether it was written out?
And you're on 303?
Yeah.
Yeah, we would prevail under 303.
I'm saying if you don't prevail under 303.004B, if this resolution doesn't do the trick? Is that all you've got? Would your prior practice, you were describing to Justice Boyd why you think you would win even if you didn't have this resolution. Would that prior practice, if the resolution doesn't satisfy 303.004B, would your prior practice do it? Is there any way you could win, in other words, if we conclude that you must satisfy 303.004 and we don't think the resolution does?
I believe so, but I need to have the statute in front of me to make sure I've got that. Let me look at that real quick here. Let me look at this provision real quick. Yes, we would prevail because it says that you need to, this simply discusses having an agreement between the board of directors and the professional corporation on the price and terms. And so that agreement did in fact exist. What I was looking for was a written requirement that's not present here, but that is present in Chapter 21.
And the agreement that you had before the 2014 resolution, what does it do exactly? And I promise this will be my last question. What does it do exactly that the 2014 resolution does not do? Because I'm not saying that this is how I'm going to come out, but if I don't think that the resolution qualifies, what in the prior practice is different that would satisfy it?
Well, the resolution was a memorialization of the prior practice.
So there is no difference?
There's no difference in terms of that it includes redemption. The prior practice would have been broad enough to include matters such as reacquisition of shares or redemption, departing shareholder issues.
I think I
so
understand.
in that sense, it covered it, and in that sense, the resolution, the 2014 resolution also covers it.
Any other questions? Thank you, Mr. Cook. Mr. Myers, are we hearing from you? No, you still got 5 minutes, at least.
May it please the court then, Mr. Chief Justice, to take up kind of where we left off. We're not drawing on a blank slate when the resolution is signed. There have been shareholders who have departed the firm in the past, who were neither paid any consideration for their shares nor were they paid any upon their exit. These are facts which were known to Mr. Skeels and the other 3 shareholders who signed the 2017 agreement.
And what does the record show about whether Mr. Skeels agreed to that under B1?
Other than Mr. Skeels' testimony that he agrees that redeeming shares would be covered by the resolution. It would
but it
be
would
considered.
Give the firm the authority to commence that process, sure. But at B1 says there has to be agreement between the board of directors or the 3 gentlemen specified in the resolution acting on behalf of the firm and the shareholder. So what in that resolution or in the practice gives the authority for the 3 gentlemen named in there to agree on behalf of the shareholder?
It by definition has to include that right. And I think that's an awfully good point, because here's what occurs to me and has occurred to me throughout this thing. Mr. Skeels over here actually testified in front of Judge Walker down in Fort Worth that in his view, he had the right to remain as a shareholder of Friedman, Suder, and Cook, even after he'd been fired, into perpetuity.
And that sometimes happens with corporations, right? Shareholders get fired, but they don't forfeit their stock.
Not in professional corporations, Judge, because if you're not an employee of that firm, you're no longer qualified as a stockholder. It's that simple. It works that way in every law firm that everybody in this room has ever been a part of.
But you still have to redeem the shares.
Well,
they don't just evaporate.
You do have to redeem the shares under some constraints, and there are constraints that are placed upon the shareholders that are given the power to run the law firm. And there are constraints that this court has recognized as recently as Ritchie against Rupee and the estate of Poe. They're a fiduciary obligations that these gentlemen, this resolution imbues them with the power to make these decisions. It's intentionally broad. There's nothing wrong with breadth. It's intentionally simple. There's nothing wrong with simplicity.
And there's probably something like that for most closed corporations in the state, wouldn't you agree, that says, you know, these people can conduct business on behalf of the firm?
I can't speak to what other law firms may do. I can tell the court, as the court likely knows, that sometimes the painter's house does not get painted. Sometimes every I is not dotted and every T is not crossed, but let's not forget that we are dealing with extremely sophisticated lawyers, litigants. Mr. Skeels was ultimately not an acceptable partner, but he is a fine attorney and he is skilled. And it was not in some vacuum that he signed this agreement when he did, and he did not question at the time its breadth, its scope, what it applied to. He did not come to the founding partners and say, well, if I ever decide to leave, what are we going to do about redeeming my shares?
Well, if we assume that there is a document similar to this one for most closed corporations in the state that gives certain people the power to act on behalf of the firm and to manage it for the other shareholders and that sort of thing, it sounds like from your co-counsel's argument that your position is that in every single one of those companies, those people are empowered to redeem the shares of all the other shareholders for zero. Is that right?
If that were the habit and practice of that particular firm, I would argue yes.
It sounds more like another way of thinking about your argument is that you're essentially arguing that the shares have zero value at redemption.
That was the decision.
As a factual matter.
Yes, that was the decision that the founding partners made, and I think as a practical matter was absolutely true as well.
The statute envisions either an agreement as to the price, which you don't have, or pre-existing specification of the amount. But in a case where there's neither, would the court need to assign some value to the shares? And here you'd argue that the value is zero?
That was actually going to be my opening point, but I got a little sidetracked. But if you think about it, I haven't seen anywhere in Mr. Skeels' briefing, nor did I hear it in his argument, where he suggests what result, what remedy that he's asking the court to provide to him. Because as best I can tell, the solution that he seeks will inexorably bind this law firm to Mr. Skeels by some sort of Gordian knot that can never be escaped from. Because he says, no matter what the price is, if he doesn't agree with it, he doesn't have to take it. He also says that the statute provides that we don't have to pay him. So what we're stuck with him from now on, that can't possibly be the law.
There's nothing in the Business Organizations Code that allows that. I mean, I'll go read it, but I thought there were provisions in there if people can't agree to allow a court to step in and get it done.
I don't find it in there, Your Honor. I don't find it.
I think there are for partnerships, but not for corporations.
I would tend to agree. We've looked at it, but again, I can't be. Well, the court knows what our position is. The reason that the resolution is so broad is to encompass all potential problems. And Mr. Skeels signed it. He signed it without any duress. And consideration, yes, of course there was consideration. For one thing, he got to keep his job. He was paid hundreds of thousands of dollars over the ensuing years.
That's kind of the question, though. If someone were a shareholder and you got to the end of the year and the day before the distribution, having worked for all these months, 11 months and 30 days, to generate income for the firm, and then they sort of cash out your shares at zero, that seems problematic, but I don't see where in your argument they couldn't do it.
I think that they're...
Might have trouble recruiting new partners if they did that, but I'm not sure...
Well, I think those are two different scenarios, and I think it has to do with what the firm's habit and practice and policy had been up to that point in time. You'll remember, you'll see it in the briefing, it's part of the record. The way the firm operated is that all of the lawyers were paid on these contingent fee cases as they came in, whether they worked on them or not. I mean, that's just the way that the firm operated at the time that Mr. Skeels became a shareholder and had operated for the 30 years prior to that time. Again, it was no blank slate. These things were known. I see I'm out of time.
Has the firm in the past ever paid any value to redeem stocks other than zero?
The record reflects the answer is no.
Any other questions?
Thank you, Your Honor.
Thank you, Mr. Myers. Mr. Skeels, you have 5 minutes.
What, maybe while you're doing that, you can answer, what do you propose the solution would be if a shareholder leaves the firm and goes to practice with another firm, claims to still have shares that have been unredeemed, is not doing anything to advance the firm, maybe in competition with the firm? What do you propose the remedy be?
Well, there are a number of possibilities. They can get their shares back. I don't get to hold them in perpetuity if they want to get them back. There are freeze out and squeeze out tactics that are discussed in more detail in Professor Schneider's amicus brief. I don't claim to be an expert on corporate law, but there are ways to restructure the corporation and to get those shares back. Now, ultimately what happens is the corporation has to pay fair value for them. They could also negotiate a repurchase. There hasn't been much effort in that regard. But there are ways to get the shares back. There's also a reverse stock split that's discussed in the amicus brief. There are ways to get their shares back if they want them.
So the remedy, in your view, is that absent either an agreement that satisfies 303-004B1 or specified price and terms that satisfies B2, absent either of those, then there's this common law right to fair value that kicks in as determined by the court? Is that the remedy as you see it?
Correct. And for example, if I'm not aware of a statute whereby I could force them to buy out my shares, but there's good case law, including as discussed in Ritchie, where if I prevail on a breach of fiduciary duty claim, for example, the court in its equitable powers could order the buyout.
Here, why it just seems like if it's true that the evidence is that for as long as this firm existed, every time they ever redeemed a departing shareholder's shares, the value was zero. And in light of your termination and the payment of the $50,000 and all that, why isn't the fair market value zero here? What are we fighting over?
Well, because the fair market value would be based on the sale of the firm as a going concern. That's the case law. Let me give you a record cite to 4CR.
But you are an individual minority shareholder.
Right.
So that's deeply discounted from the firm's value as a going concern because your individual share is not liquid and can't be sold as an individual share. And so that may not be the measure, but did you adduce evidence of what the value, the fair value was for the share if it's not zero?
I did. And in fact, we had an expert opinion from Mr. Kasparis that's in the record. He valued the corporation if being sold as a going concern, which there's common law. There's two cases from Fort Worth Court of Appeals, one from Tyler, one from Dallas that we cited at 4CR 2337. And that's the way you value the firm, is as a going concern. And
even in a personal services firm that depends entirely on human capital that can walk out the door at any minute.
One of those cases, Justice Bland, was valuing a small contingency fee plaintiff's patent litigation firm. It's directly on point. And the shares are not worth zero. To Justice Devine's question, I'm a little bit offended by the answer, asked if anybody got anything of value when they left the door. I have yet to see those documents. In 7 years, I've yet to see the documents of the separation agreements for the lawyers that walked out the door. I haven't gotten them yet. I expect to get back to the trial court and finally have my day in court to get access to the books and records. But for them to say that when some of these lawyers left and nothing of exchange value was given is frankly a little bit offensive. Also, the shares do not have zero value, even though I couldn't force them to buy me out right now. If I walk out the door today and get hit by a bus, my wife owns those shares. And since she's not a licensed professional attorney, there is a statutory provision whereby tomorrow they would have a statutory obligation to buy out those shares at fair value, and the way that would be calculated would be looking at the firm as a going concern. Again, 4 CR 2337 at note 14, I provided 4 case sites there of how that goes down. I agree with Mr. Meyer's comment that the resolution was not signed against a blank slate, but rather there are corporate documents that govern this case, including at 4 CR 2851. If you look at that record site, you will see that the corporation intended to be bound and governed by the code, and there's nothing in the resolution, as Justice Birdwell pointed out, nothing in the resolution that suggests expressly or impliedly that the firm intended to do anything going forward inconsistent with the code.
Any other questions? Thank you, Mr. Skeels. The case is submitted. That concludes the arguments, and the case is set for this morning, and the marshal will adjourn the court.
Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.